Hello students and welcome to the lecture. So students, as we know that we are covering the salient features of the constitution, and basically you could say that these are the topics we have scheduled for the discussion under this series. Okay? Like the introduction part, okay? Like the salient features of the constitution, like the criticism of the constitution, like the schedules of the constitution at a glance, like the sources of the constitution at a glance. All right? We have completed the introduction so far. We have been discussing the salient features of the constitution and what we are left with: criticism of the constitution, schedules of the constitution at a glance, and sources of the constitution at a glance. All right. So we will continue from where we had left in the previous lecture. All right. So basically, you could say that we had finished the salient features of the constitution. Now, what we are left with, we are left with to discuss the criticism of the constitution. Okay. Like you could say, everything in this world having its own advantages and disadvantages. Advantages and the disadvantages. So does the Indian Constitution. All right. So far, we had only discussed about the advantages, like what are the things provided by our Constitution. Now, we are required to discuss the disadvantages of the Constitution. Or you can say the limitations and criticism of the Indian Constitution. All right. So let's start discussing. The first, the Constitution of India, as framed and adopted by the Constituent Assembly of India, has been criticized on the following grounds. The first ground of criticism is the borrowed constitution. All right. The critics opened that the Indian constitution contains nothing new and original. Because as we had discussed in the earlier, or you can say in the starting of this topic, that basically the Indian constitution has been borrowed from various sources. All right. So because of this, many critics who criticize the constitution, they said our constitution is borrowed, so that's why it does not have any new and original thing. Okay. They describe it as a borrowed constitution or a bag of borrowings or hodgepodge constitution. Okay. Or a patchwork of several documents of the world constitution. It means that basically the criticist emphasized that basically in India, when we were drafting our constitution, our main aim was on copy and paste. It means that instead of introducing something new, instead of making something new, basically what we did, we just do copy and paste. All right. So that's why the first words they use for the constitution is borrowed constitution, bag of borrowings, and the hodgepodge constitution, also called as a patchwork of several documents of the world constitution. However, the criticism is unfair and illogical. It means that whatever they are saying, this is unfair and illogical. Why? This is because the framers of the constitution made necessary modifications in the features borrowed from other constitution for their suitability to the Indian conditions, at the same time avoiding their faults. It means that, however, we borrowed provisions from various sources or constitution. All right, but only for the catch up of ideas. Okay, it means that basically we have got their base. All right, and we have made various modifications into that particular base or ideas so that it could be fit in our country. All right, for example, we could say about the secularism. Just take an example. All right, secularism basically we had borrowed from the Western constitution, right? That is true, that we had borrowed from the Western constitution, but only the idea or the base. Why? Because as we had discussed, the secularism in West is a negative secularism, or also called as a no interference. All right, it means as we had discussed, in West the governments do not have to do anything with the religion, even they do not interfere in it. All right, at any aspect. But when we talk about India, the Indian constitution is positive secularism, or you could say interference and protection. It means in India, basically, the government is not inclined towards any particular religion. That is true. But also, the government could interfere in the religious policies so that the constitutional provisions could be implemented fairly. All right. So, you could say, however, we had borrowed the ideas, but we had done the modification so that they could be suitable to the Indian conditions, at the same time avoiding the faults of the ideas, or you can say avoiding the conditions which are prevailing in their countries from which the ideas belong to. All right. While answering the above criticism in the Constituent Assembly, Dr. B. Rao Ambedkar, who was the drafter of the Constitution and the chairman also of the drafting committee, said, one likes to ask whether there can be anything new in the Constitution framed at this hour in the history of world. Okay, so he said more than 100 years have rolled over when the first written Constitution was drafted. And what was that? That was an American Constitution. Okay, so remember, if we talk about oldest constitution and lengthiest constitution. So the oldest constitution is American Constitution. Okay. And the lengthiest constitution is Indian Constitution. Okay. That is the thing. So remember this thing. So he said that more than 100 years have rolled over when the first constitution was drafted. It has been followed by many countries reducing their constitutions to writing. What the scope of the constitution should be has long been settled. Similarly, what are the fundamentals of the constitution are recognized all over the world. Given these facts, all constitutions in their own provisions must look similar. The only new things, if there can be any, in a constitution framed so late in the day are the variations made to remove the faults and to accommodate it to the needs of the country. The charge of producing a blind copy of the constitution of other countries is based, I am sure, on an inadequate study of the constitution. So basically, he said that the first constitution of the world was made by America. All right. And when we were drafting our constitution, it means from the time period of 1946 to 1949. During this time period, basically, he said that more than, you can say more than, or you can say many countries have made their constitution based on the ideas of the American Constitution to reduce their constitutional writings. All right. And you could say over the period of time, the fundamentals of the constitution are recognized all over the world. Like if any country is going to adopt any type of constitution, then what should be ideals and the aspiration mentioned in the constitution? This is well recognized all over the world. All right. Due to which all the constitution in the world are look very much similar. Why? Because the ideals and the aspirations are common. All right. But how the Indian constitution could be differ from them? Why? Because as I have told you, we have borrowed ideas only. But we have also made several changes, not challenges, basically the modifications. Modification or changes as per need of our country, not constitution. Okay, that's make Indian constitution fresh and new. Got it? And he even added that if someone criticizing the constitution and saying that the constitution is just a copy paste of the world's other constitution, then the person is must be inadequate educated about the study of the constitution. Okay, that was saying by Dr. B. Rao Ambedkar. The next point was a carbon copy of 1935 Act, or you can say the Government of India Act 1935. The critics said that the framers of the constitution have included a large number of the provisions of the Government of India Act 1935 into the Constitution of India. And also we had discussed that the you can say the major weightage of you can say copying pasting goes to the Government of India Act 1935. Okay, hence they call the constitution as a carbon copy of 1935 Act or an amended version of 1935 Act, or you can say the modified version. For example, Anne Srinivasan observed that the Indian constitution is both in language and substance a close copy of Act of 1935. Okay, so he is the person who pointed out this thing. All right. Similarly, Sir Evior Jennings, a British constitutionalist, said that the constitution derives directly from the Government of India Act of 1935, from which, in fact, many of its provisions are copied almost textually. It means that both of them, and Srinivasan and Sir Ivor Jennings, they said that if we look at both the aspect, language as well as the substances put into the constitution, then we will find that it is a carbon copy, or you can say dicto copy of the Government of India Act 1935. So that is the criticism which they have posted. But further, there is another person, P.R. Deshmukh, a member of the Constituent Assembly, commented that the Constitution is essentially the Government of India Act 1935 with only adult franchisee added. It means that almost everything we have in Constitution was already presented in the Government of India Act 1935. We had only added the adult franchisee from our side. Okay. The same Dr. B.R. Ambedkar answered the above criticism in the Constituent Assembly in the following way. As to the accusation that the draft constitution has reproduced a good part of the provisions of the Government of India Act, I make no apologies. There is nothing to be ashamed of in borrowing. It involves no plagiarism. Nobody holds any patent rights in the fundamental ideas of constitution. What I am sorry about is that provisions taken from the Government of India Act 1935 relate mostly to the details of administration. So basically what he's tried to say, he said that yes, we have borrowed the provisions from the Government of India Act 1935, and there is no shame of doing this because the same act was passed for the administration of the country, which was India. And after the independence, basically, we are also governing the same country. So if the administration provisions were there in the Government of India Act and the same country is supposed to be administered, then what is a shame and what is a plagiarism in borrowing the things? All right. Thereafter, another one is un-Indian or anti-Indian. According to the critics, the Indian constitution is un-Indian or anti-Indian because it does not reflect the political traditions and the spirit of India. They said that the foreign nature of the constitution makes it unsuitable to the Indian situation or unworkable in India. In this context, K. Hanumanthia, a member of the Constituent Assembly, commented, "We wanted the music of Veena or Sitar, but here we have the music of an English band." Okay, that was because our constitutional makers were educated that way. Okay. Similarly, Loknath Mishra, another member of the Constituent Assembly, criticized the constitution as a slavish imitation of the West, much more a slavish surrender to the West. So what about all this thing? When we will talking about the sources of borrowing, then I will show you the sources from where we have borrowed the constitutional provision. Then only you will be understand why we are saying that it is a direct copy paste of Western culture. All right. Further, Lakshmi Narayan Sahu also a member of the Constituent Assembly, observed that the ideals on which this draft constitution is framed have no manifest relation to the fundamental spirit of India. Basically, all of these critics were trying to say we had just copy paste the Western ideals in our constitution, and our constitution is not based on the fundamental spirit of India, on the grassroots problems of India that must be present while formulating the constitution. This is their point of view. Okay, this constitution would not prove suitable and would break down soon after being brought into the operation. That was their saying. Thereafter, another criticism was un-Gandhian constitution. According to the critics, the Indian constitution is un-Gandhian because it does not contain the philosophy and ideals of the Mahatma Gandhi, who is often regarded as the father of Indian nation. They opined that the constitution should have been raised and built upon village panchayat and the district panchayat. Now, here's the thing. Like in the, you can say, the salient features of the constitution, we had discussed the three levels of government, right? We said in India we had the three levels of the government, means the central, the state, and the local. Okay, but we know the local governments later added in the year of 1992. When the constitution was drafted, there were only two types of government, federal and the state. So that's why the critics of that time, they were claiming that the Indian constitution must contain the governings from the village panchayat and the district panchayat level. Instead of this, basically we had adopted the culture of federal system, means the central government or the state government. In this context, the same member of the Constituent Assembly, K. Hanumanthia, said that is exactly the kind of constitution the Mahatma Gandhi did not want and did not envisage. T. Prakasam, the another member of the Constituent Assembly, attributed this lapse to the Ambedkar's non-participation in the Gandhian movement and antagonism towards the Gandhian ideas. It means that kind of allegations. Thereafter, the elephantine size. The critics states that the Indian constitution is too bulky, too detailed, contains some unnecessary elements. It means that it is hard to understand the constitution by general people, or you can say by the common man of the country. All right. Sir Ivor Jennings observed that the provisions borrowed were not always well selected and that the constitution, generally speaking, was too long and complicated because the language was technical. And as we had discussed, that they even said the Government Act of 1935, its language had been directly copy pasted into the constitution and the language was technical. All right. So similar things they had pointed out. In this context, A.V. Kamath, a member of the Constituent Assembly, commented, the emblem and the crest that we have selected for our assembly is an elephant. It is perhaps in consonance with that our constitution too is the bulkiest that the world has produced. Also said, I am sure that that the house does not agree that we should make the constitution an elephantine one. They all were claiming that the constitution is too long and too large for a normal country. Thereafter, paradise of the lawyers. According to the critics, the constitution is too legalistic and very complicated. Why? Because the makers were generally the lawyers. They opined that the legal language and phraseology adopted in the constitution makes it a complex document. The same Sir Jaivar Annings called it as a lawyer's paradise. In this context, H.K. Maheshwari, a member of Constituent Assembly, observed the draft tends to make more litigious, more inclined to go to the law courts, less truthful, and less likely to follow the methods of truth and non-violence. If I may so, the draft is really a lawyer's paradise. Okay, there is just a reading part. That's why I'm not explaining it to you. It opens up vast avenues of litigation and will give our able and ingenious lawyers plenty of work to do. Okay, so these were some kind of criticism they were claiming. Similarly, P.R. Deshmukh, another member of the assembly, said, I should, however, likely to say that the draft of the articles that have been brought before the House by Dr. Ambedkar seems to my mind to be far too ponderous, like the ponderous tomes of a law manual. Document dealing with the constitution hardly uses so much of padding and so much of verbiage. Perhaps it is difficult for them to compose a document which should be, to my mind, not a law manual but a socio-political document, a vibrating, pulsating, and life-giving document. But to our misfortune, that was not to be, and we have been burdened with so much of words, and words, which could have been very easily eliminated. Okay, so these were all kind of criticism which the constitution has achieved. Thereafter, the schedules of the constitution at a glance. These are just a schedule, so I'm not going to explain you. I'm just showing the table. You are required to see the details and you will get the notes of them. First schedule contains the name of the state, territorial jurisdiction, and other things, similar like the second schedule. Thereafter, third schedule, okay, here you could see them. Fourth and the fifth schedule, all right. Sixth, seventh, and the eighth schedule. Ninth, 10th, 11th, and the 12th schedule. So here we have seen the 12th schedules and the contents of this. There is nothing to explain in them. You are only required to revise and keep this thing in your mind for your examination. Okay. Thereafter, the sources of the constitution at a glance. From the Government of India Act of 1935, we had brought the federal scheme, Office of Governor, Judiciary, Public Service Commission, emergency provisions, and the administrative details. From the British Constitution, parliamentary government, rule of law, legislative procedure, single citizenship, cabinet system, prerogative rights, parliamentary privileges, and bicameralism we have brought. From the American Constitution, fundamental rights, independence of judiciary, judicial review, impeachment of the president, removal of Supreme Court and High Court judges, and post of vice president we had brought. From Irish Constitution, directive principle of state policy, nomination of members to Rajya Sabha, and election method of president we had brought. From Canadian Constitution, federation with a strong center, vesting of residual powers in the center, appointment of state governors by center, and advisory jurisdiction of the Supreme Court we had brought. From Australian Constitution, concurrent list, freedom of trade, commerce and intercourse, and joint sitting of the two houses of parliament. Weimar Constitution of Germany, suspension of fundamental rights during emergency we had brought. From Soviet and USSR, now it's known as Russia, we had brought fundamental duties and ideals of justice like the social, economic, and political in the preamble. From the French Constitution, Republic and the ideals of liberty, equality, and fraternity in the preamble we had brought. From South African Constitution, procedure for amendment of the Constitution and election of members of Rajya Sabha we had brought. And from the Japanese Constitution, basically procedure established by law we had brought. Okay. So students, here we had finished the salient features of the Constitution. In the next lecture, we will start with another important series. Till then, just revise all the facts and figures which we have discussed in that particular series of the salient features of the Constitution. So here we have finished this lecture. All right. In the next lecture, we will start with another important series. Till then, just revise the facts and figures, and thank you.